Yes, I've got 5 questions for the Senior Minister of State. The first question is, in view of the government status as the largest single shareholder of Keppel, will Temasek Holdings call for an extraordinary general meeting with a view to pursue civil action against board members and senior executives found responsible for the bribery scheme for breach of fiduciary duties and to seek equitable compensation from those responsible? The second question pertains to the questionable P61 contract, which amounted to hundreds of millions of dollars, and it would have likely required board approval for it to have been approved. Did the Keppel board, is the government aware whether the Keppel board gave the CEO broad powers to enter into the contract? If not, what is the nature of the board's oversight and their culpability in the bribery scheme? Is this something the public prosecutor or the CPIB is going to look into, or is this a matter for shareholders to consider? Thirdly, in its information release, the US Department of Justice shared that a KOM subsidiary in Singapore paid the bribes amounting to $70 million into an entity based in Florida and Miami. What is the name of this subsidiary? And this is just a question of fact. And who are the officers of this subsidiary? Fourthly, a former Keppel CEO and senior advisor, Mr. Chu Chao Beng, was the Singapore ambassador to Brazil from 2004 till 2016, I believe. Was Mr. Chu removed as ambassador because of his involvement or knowledge of the bribery scheme? And if so, and I stress if so, which month or year did the government first come to know of Mr. Chu's involvement? Finally, is the CPIB or the public prosecutor investigating whether Mr. Chu used his position as ambassador to dishonestly assist Keppel secure contracts corruptly in Brazil? My final question pertains to the matter of the identities of the individuals identified in the deferred prosecution agreement. There is a dissonance between what the public reads in the newspapers for individuals who are being investigated. For example, the general manager of Ang Mo Kio Town Council, no charges, I understand, have been preferred against him yet, but his identity, his name is well known to the public. How does the minister reconcile that with a non-disclosure of the names of the individuals involved in the Keppel matter? Thank you.
Let me just deal with the last question first, which I think he wanted to know, how does the government deal with the fact that the names are out there? Government's position is very simple. The government deals with the government's actions. So the government's actions are, when investigations are ongoing, we don't disclose identities of people being investigated. What other people may say outside, what other information may be floating outside, what other comments may go on in social media, that is separate. But as a government, as an investigation authority, the government does not disclose names of individuals who are being investigated, and we are not alone in that. All civilized jurisdictions who have rule of law uphold that principle simply because, as I mentioned earlier, you don't want to prejudice either the investigations or the persons being investigated, depending on how the investigation might turn out. With respect to the first question, I think Mr. Singh asked, why does the government, can the government, as a shareholder, call a meeting and I think ask for a resolution to be passed to commence civil action? I think that was the thrust of the question. Let me just correct a few factual inaccuracies here. First, government owns 100% of Temasek. Government is not a direct shareholder of Keppel. That's number one. Temasek owns just over 20% of Keppel Corporation, which is not the entity in question here, which means there's 80% of other shareholders. Keppel Corporation then owns 100% of KOM, which is the entity in question here. So the general principle of corporate governance, with which Mr. Singh is familiar as a lawyer, is that the shareholders deal with their companies in which they have shares at the shareholder level. Shareholders appoint the boards. The boards then, depending on whether the members are executive, non-executive, it's their business to make sure that the policies, etc., for the company are proper, that governance is proper. and then the day-to-day operations are done by the executive team or the executive management. As I've mentioned earlier, in this particular instance, the government and Temasek does not interfere in the day-to-day running or management of the companies, of Temasek portfolio companies. What I can say, and what I can point Mr. Singh to, is what is already in the public domain, which is in the DPA, which is that the company, this is paragraph 4D of the DPA, which I'm sure Mr. Singh is familiar with, the company has engaged in extensive remedial measures, including taking disciplinary action against 17 former or current employees in relation to the misconduct described in the statement of facts. They have caused 7 employees who participated in the conduct described in the statement of facts to separate from the company. They have issued demotions and/or written warnings to 7 employees who failed to detect the misconduct and failed to take appropriate steps to mitigate corruption and compliance risks. And they've imposed approximately 8.9 million in financial sanctions on 12 former or current employees as part of the disciplinary process, and have conducted individualized anti-corruption and compliance training for 6 employees. Anything further than that is a matter for the Keppel group, or for the company in this case, to determine, not for the government. Now, going back to, I think Mr. Singh had a couple of other questions. On the P61 contract, he asked whether, I'm sorry, could you just clarify your question on the P61 contract?
Senior Minister said the question really pertained to the nature of the board's oversight over that contract, and what would, if indeed they had knowledge or they were involved in that contract, what is the nature of their oversight and their culpability in the bribery scheme, and specifically, is this something that the CPIB or the public prosecutor is looking into?
That is actually not so much a question for the government. That is a question of, as to what was known, not known within the Keppel Group, is really a Keppel matter. I think the only thing that I can do here, which would be useful, is to point Mr. Singh to one of Keppel's media releases, where Keppel said that the current boards of directors of Keppel Corporation and its unit, KOM, were not aware of the illegal payments made to secure projects in Brazil. Now, that is Keppel's position. As far as the government is concerned, as I have explained, the government is shareholder in Temasek. Temasek has a just over 20% shareholding in Keppel Corporation, and the operations of Keppel are run by Keppel itself. Mr. Singh also had a question on the name of the subsidiary company. I do not have that information with me, and he asked about the circumstances in which Mr. Chu Chao-beng may have stepped down as ambassador. I do not have that information. What I can say is that he has stepped down and he is not involved in an ambassadorial role at the present time.